You've got the judgments
Yes.
with sworn.
Silence, all stand. The High Court of Australia is now in session. Please be seated.
The Chief Justice of Australia, Sir Gerard Brennan, is in his last year of office. Under the Constitution, all High Court judges must retire at the age of 70.
We have a society that is ruled by law. The options to being ruled by law is being ruled by power, and that can be a source of oppression. But the law can rule only so long as there are impartial arbiters who can enforce the rule of law. It is very important that the public should be satisfied that the judges are not, as it were, working with governments, because frequently the issues that arise concern the exercise of power by governments. The judge must be independent of any source of power or influence that could impermissibly tilt the scales of justice.
In a 4-3 ruling, the High Court has decided that pastoral leases do not extinguish native title over 35,000 square kilometres of Cape York, subject to the Wick claim.
The highest court in Australia have made this decision, and we will not lose that. That's where we are being recognised now.
The Wick and Theore peoples celebrated a victory, but they did not secure native title. That was never a question for the High Court. Aboriginal people could now make a claim over pastoral leaseholdings, but the court found that where a conflict exists between a pastoralist's rights and native title holders, then the pastoralist will prevail. The Wick decision, as it has become known, unleashed 12 months of criticism of the High Court of Australia, unlike that at any other time over its 95-year history.
It hasn't covered the High Court in glory, and it has left the Australian community at the edge of an abyss.
Welcome to the High Court. Please come in.
It's not a matter for the courts. People get elected to resolve these sorts of problems.
A few exhibitions are often held in the High Court by the various embassies, cultural exhibitions, non-profitable.
At the end of the day, the Parliament is the highest court in the land.
Last case here, we have a sculpture of the longest-serving judge in the High Court, Sir Edwin McTiernan. He was 45 years and 9 months on the bench.
The perception has developed that some judges believe it is their role to give the Parliament a hurry on and do things that they think the Parliament should have done.
And this, of course, is the Constitutional Court, and this is where most of the matters before the full court will be heard.
One of the essential things of a judge's makeup is a sense of absolute independence of mind. Let the heavens fall, justice must be done. Now, for that reason, if judges were going to be concerned about justifying their decisions, as distinct from their reasons, to the public or to the media or to government, then the judges would start to trim their decisions in a way which would be more presentable or more acceptable or more palatable. That would be absolutely inconsistent with judicial independence and would be the easy way to the erosion of the rule of law. Judges would simply become the mouthpieces of power.
Judges are actually pretty sensitive plants. They don't feel that they can answer back, but when criticised as savagely as some of this court has been, they tend to draw in their horns, so that criticism, which fairly unthinkingly indulged in for party political purposes, can actually be very damaging to the court and to the country. And I think we've seen some pretty shameful examples of that in the last year or so. All of that has an impact on the court. The court is not going to get its fingers burned if it can help it. But again, of course, one hopes that in the areas where they really see a constitutional imperative where they have to act, they're not going to be deterred by that sort of criticism.
No, we didn't have to, but showed a bit of interaction,
Justice Tui will dismiss the appeal.
In an unprecedented move, 5 of the sitting justices of the High Court of Australia arrived for a panel interview for this documentary film. They will discuss frankly and openly the role of the High Court of Australia and their roles as justices of that court.
It is only the individual judge who can, in the end, do the work and, most importantly, satisfy his or her own standards and conscience about the doing of the work. Nobody else can give the judge that final satisfaction that I have done what was my duty to do, and that is to express my views, stating the reasons which lead me to this conclusion. It's a lonely activity, one which can be engaged in conjunction with others, but the responsibility never shifts from the individual.
I think it's not generally appreciated that perhaps a primary, if not the primary requirement, is a capacity and discipline day after day to apply oneself to pretty complicated problems and write judgment after judgment.
And the writing never gets easier.
That's right.
I mean, I had thought at one stage that with the passage of time it might become at least a more happy situation, but the writing is very, very hard. It involves not just the research, but the articulation of issues with precision.
And you are dealing with issues. That's the difficulty. I mean, you're not a primary judge who's sitting, having heard witnesses, and who's required to make findings of fact. Now, I'm not suggesting that's easy either, but it's a different exercise. I mean, you've heard the witnesses, you've formed your own impressions as a trial judge, you've got documentation and other things that assist you in arriving at findings as to where the truth, so far as it can be ascertained, lies. But here the facts have been found. by and large, we're dealing with questions of principle.
It's not just long hours, it's intellectually intense hours. A lot of people work long hours. This is unremitting intellectual intensity.
So what sort of a life is it then to be a judge?
A life that's consciously and voluntarily assumed, and therefore no point complaining about it.
I think judges undertake the function because they're conscious of its importance to the community and because they've discovered over a professional life to find a certain intellectual satisfaction in the challenge of which Justice Gummow has spoken. But there's no doubt that it's a long, hard road.
On the 1st of January 1901, Lord Hopetoun was sworn in as our first Governor-General and Edmund Barton as our first Prime Minister. The Commonwealth of Australia came into existence under a federal constitution. The Constitution is the legal document that governs how the Australian nation functions. It sets out the role of the Governor-General and the three arms of government: the Parliament, that is the Senate and the House of Representatives; the Executive, that is the Prime Minister, Ministers and their departments; and the Judiciary, that is the courts. Under our system, all three exist separately, and yet none is an unbridled power unto itself. This is what is known as the separation of powers doctrine. The Parliament makes the laws, the Executive carries them out, but it is the courts which must determine that they are legal and constitutional. The High Court of Australia is the only court whose existence is guaranteed by the Constitution, and it is the High Court which is charged with the final responsibility of determining whether governments themselves are acting legally within the limits set by our Constitution.
It's the chief dispute resolution mechanism of society. It's there to resolve disputes between citizens and the various states of this country, and citizens of the Commonwealth, and in this country between the states and between the states and the Commonwealth. It is actually the glue that keeps society together in that sense and enables it to work harmoniously. It's often said that the High Court is political, for example, but the very nature of the function which the judiciary is asked to perform in Australia inevitably means that the political type issues are brought before the court.
Because it's part of the body politic as a whole.
And they can't be escaped.
The first High Court was established in Melbourne in 1903, and our first Prime Minister was appointed to that court, Justice Sir Edmund Barton, along with two other distinguished lawyers and politicians, Chief Justice Sir Samuel Griffith and Justice Richard O'Connor. The first 5 appointments to the court were all politicians.
Silence, all stand.
Since 1903, there have been 43 appointments to the High Court of Australia, including only one woman. On a handful of occasions, there has been controversy, but most appointments arouse little or no interest from the general community.
The High Court of Australia is now in session. Please be seated.
The swearing in of the Honourable Kenneth Madison Hayne as a Justice of the High Court of Australia.
Every appointment, though, is a political appointment in that it is made by the government of the day. There is often the hope that the judge will broadly reflect the political philosophy of the government which appoints. In theory, the judge chosen must simply be the most qualified and experienced candidate available at the time. In practice, he or she is above and beyond any political influence, once appointed to the High Court of Australia.
I, Kenneth Madison Hayne, do swear that I will bear true allegiance to Her Majesty, Queen Elizabeth II, her heirs and successors according to law, that I will well and truly serve her in the office of Justice of the High Court of Australia, and that I will do right to all manner of people, according to law, without fear or favour, affection or ill will. So help me God.
Thank you. I invite you to subscribe the oath that you have taken.
I should remain daunted until the day I retire from the job, because unless it bears in on me that what I am doing is important, is difficult, and matters, then I will not do it properly. So, yes, I'm daunted, but in a sense, so I should be.
Of course, it was daunting for all the reasons that my colleague has mentioned in his own case. I mean, they were all there. I suppose the only other thing was the need to ensure I wasn't the first and the last. One certainly doesn't want people saying, we tried a woman once and it didn't work. You know?
I'm sure that won't be the view. Mr. Attorney.
Your Honour joins the High Court at a time when it appears to be attracting more than the usual attention from the public. Decisions of the Court can be of such significance that they will be subjected to high levels of scrutiny and possibly criticism. The Government is at one with the Court in regarding public discussion of judgments of the Court as healthy and to be encouraged.
Traditionally, judges will not speak up in public in their own defence. This duty has always been left to the Attorney General.
There is currently a debate ensuing as to the proper relationship of the branches of government.
The Attorney General, as the first law officer of the country, has always had a special role to defend the judiciary from political attack. The Attorney will leave to one side his or her own political allegiances in order to take an active part in the preservation of the dignity and respect for the courts, and therefore the rule of law. The present Attorney General takes a different view.
In my view, mutual restraint, that is, judicial restraint, executive restraint and parliamentary restraint, is entirely consistent with the notion that the judiciary collectively has a role in defending themselves and their courts against criticism.
We are one, but we are many, and from all the lands on earth we come. We share a dream and sing with one voice. I am, you are, we are.
In earlier days, attacks on courts or judges with reference to their decisions brought an immediate response from the Attorney General, and attacks by members of the political branches of government were almost unknown. That is no longer the case. Attorneys General, both federal and state, have been singularly quiet in defence of the courts at times when the courts have been subject to the most acute and often ill-informed criticisms. Of course, the Attorneys General of today are seen and apparently see themselves as political figures rather than as ministers with a peculiar responsibility for the judicial branch of government. The consequence is that they are politically hamstrung in their response that they can make or are willing to make when one of their political colleagues launches a political attack on the courts or the judges. The Federal Attorney General, Mr. Darryl Williams, a distinguished lawyer whose resolute integrity is not open to doubt, has recently accepted this position.
Lots of challenges.
Can you say anything in a Is there anything you could say at all?
The Wick decision on the 23rd of December 1996 was of course not the first time that the High Court had handed down a judgment that went directly against the wishes of the political parties in power.
A crowd of more than 10,000 listened to speakers of the Bank Officers Association protesting against the Chifley government's plan to nationalise banks.
In 1948, the Labour government had passed legislation to nationalise the banking industry. The High Court of the day declared the move unconstitutional. Just 3 years later, the Menzies Liberal Country Party government moved to ban the Communist Party of Australia and to name and jail communists and others for their political beliefs. At the height of the Cold War, the High Court found that the government had no constitutional authority to do this, and the law was declared invalid. In both these cases, the court struck down legislation very close to the hearts of the governments of the time. But the politicians of the day accepted the decision, with little public comment on the court itself. In the case of the Wick decision, the attacks have been unprecedented on the court, individual justices, and even the Chief Justice.
The defence that he has given in respect of the High Court's performance is pathetic and lamentable.
The High Court's determination is the last word on the interpretation of the law as it now stands. But it's never been part of our system that the High Court makes the law.
Most English-speaking countries like Australia have a legal tradition based on what is known as British common law. For hundreds of years, British judges have been asked to make decisions as to what the law is in property, taxation, crime, and all the other areas of human endeavour. In cases where no statutes existed, the decisions the judges made built up the precedents which now go to make our common law tradition. Hundreds of volumes exist which catalogue the common law. Both the Mabo and the Wick decisions were common law decisions, that is, judge-made law.
There has been a lot of criticism from politicians today that the court is overstepping its role by making new law. The court has always done that. The court is not doing anything different than it's done in the past in terms of making law rather than simply declaring what the law is. It's an inevitable function of the highest court of appeal in the legal system.
At least in the area of constitutional law, which is where a lot of this comment has arisen, that these cases are before the court, and the court has no choice, assuming that they raise, as they do, legal issues, has no choice but to determine those issues.
Not only is there no choice, but a federal compact could not work but for the existence of an independent judiciary attending to the resolution of the problems that necessarily arise.
So what do you do when you receive such ill-founded criticism?
Nothing.
Soldier on. Grin and bear it.
Keep writing the judgments in pending cases.
Please be seated.
Call the next application.
Hundreds of matters come before the High Court every year. Under the court's appellate jurisdiction, motor vehicle accidents or even backyard disputes may be heard, but only if they raise important legal questions. A case must be mounted at a special leave hearing. If leave is granted, then the matter will proceed for determination.
The second reason arises...
Well, how do you say that arises? I mean, how do you say that arises in the context of a case in which your client went through a red light?
Well, we say that in this particular case, the trial judge correctly applied the approach that should be applied, namely to have regard to primacy of traffic control lights, but also to recognise the fact that other road users will not always be able to react or will necessarily not have regard for their own safety.
But it was an extraordinary result before the trial judge, was it not? I mean, not only was there a finding that the plaintiff went through a red light, but also a finding that the defendant, in turning out of Coward Street into Burke Street, was turning with a green arrow in his favour.
Your Honour will appreciate that the vehicles...
What was even more extraordinary to my mind is that the defendant was held to be 85% responsible for the accident.
Almost everybody on the road will take the view that if you've got a green arrow, you're in the right and you're entitled to turn right without worrying about what's not stopping at red lights.
Well, Your Honour, that, with respect, is why we have so many collisions at intersections.
Well, you may, but look, this is just a question of fact at the best. The highest you can put is the Court of Appeal disagreed with the trial judge, in my view, correctly disagreed with him, and that's the beginning and end of the case.
Well,
there's no special leave point in this case, Mr. Miller.
Well, it seems to be the consensus. We had 3 other points to develop, Your Honour.
Certainly the acceptance of judicial office does dictate certain consequences for your ability to move in and out of various places that you might otherwise have wanted to go to and exercise a degree of discretion in the invitations you accept and so forth. But we all have lives. I mean, you know, we're all like other human beings, you know. We have to wait in queues in the outpatients departments. You know, we've got to go and front up
Do the shopping.
Do the shopping in the supermarket, front up to the school teacher on parent-teacher night. You know, we all do. We've all got lives that take us out into
It all seems to
places
assume that you don't grow up in a family.
Yes.
And that you don't have any friends. I mean, it's a matter for everyone what their range of friends is. But if you've grown up, as, say, some of us have, with young children and seen them move from birth to adulthood, I mean, to talk about my case with 5 daughters, all of whom now are adult, to think that you could grow up in that situation without being exposed to a whole range of ideas. And I don't overlook my 2 sons, but I mean, daughters are rather more
trouble.
No. I was looking for the word. The word I was going to use was pressing in relation to their ideas. I mean, it's just unreal to think that you can grow up in that situation without understanding what's happening in the world around you. And I mean, I think probably what people really mean, in a sense, is that you're sitting in court a lot of the time, and particularly if you're an appellate court, it's a judge to lawyer interaction. I mean, you're not seeing witnesses giving evidence as you do if you're a trial judge.
It is a rarefied atmosphere up here in the High Court.
Well, you mean it's quiet.
You
A famous American judge said that the US Supreme Court had the quiet of the eye of the hurricane, and that's true to an extent. It doesn't mean one doesn't appreciate there's a hurricane out there.
Court's ready, Judge.
Silence, all stand. The High Court of Australia is now in session. Please be seated.
Call the first matter for judgment.
Kruger and others in the Commonwealth of Australia. Bray and others in the Commonwealth of Australia.
These matters were heard in Canberra by Justices Dawson, Toohey, Gaudron, McHugh, Gummow and myself. In each case, I would answer questions 1 and 2 in the negative. Therefore, no answer to the remaining questions is required. I publish my reasons.
In 1918, the Commonwealth Government passed legislation that made provision in the Northern Territory for the taking of Aboriginal children from their parents. That act was challenged in the High Court by one of those children forcibly removed, Alec Kruger, a member of what is now known as the Stolen Generation.
Is restricted by an implied freedom. The judge sometimes is led to a most unpalatable decision, simply because the judge is bound to apply the rule of law. And when that happens, it might appear as though the judge has reached a decision which isn't in accord with public sentiment. Now, the judge can't really say, now look, I've got to explain all over again what I've set out in this technical document, which is the reasons for judgment. And section 16 and 67, subsection 1, paragraph C of the Aboriginals Ordinance 1918 of the Northern Territory. Although there is a misunderstanding, it is usually a misunderstanding which arises because there is a concern about the result that is reached in a case, as distinct from the reasons which have led the judge to the decision. Unless that distinction is understood, it will not be appreciated that the reasons for the decision provide the justification for the exercise of the power of the judge.
In a majority decision of 5 judges to 1, the court found that the ordinance that governed the removal of the children was not unconstitutional.
The people have been forced in urbanisation, forced assimilation, deny their natural justice of culture. You can rave around for culture of the North. They are fortunate, they are lucky. But we're not lucky, we've been denied it.
That's right.
I am bitter.
There's some justice we need to come to the High Court for some decisions, and they've knocked us back. And they've more or less said that what they did was okay. And we say it was wrong. And we'll always say it was wrong. And we'll tell the world it was wrong. We'll keep saying that it was wrong. We're not going to stop. We're going to keep going.
It didn't decide the justice of the issue. I mean, I don't think there's anyone in this country today who could seriously say that stealing an Aboriginal child from its mother and institutionalising it for the rest of its life so that you never see your parents again is a just act. It may be constitutional, but it certainly isn't just. I think it's unfortunate that our constitutional structure is such that the court is in a position where it makes the decision it did today.
Although there may be political questions that are involved in cases before the court, that is not to say that the court solves them by political means. It solves them by legal means. The court has no agenda. That depends upon the litigants who bring cases here. And although our primary function is to determine disputes, they're determined according to law.
Good morning.
Good morrow.
We were just asking who removed and what did
I
we remove.
did.
Well, no, it was me. You were there.
The order of removal identifies by some number. We're ready to go?
Yeah.
That's right.
Go next week, but it'll take me 6 months. Just
Silence, all stand. High Court of Australia is now in session. Please be seated.
Less than a week after the Kruger case, another vital constitutional judgment.
Ha and another, and the State of New South Wales and others, Walter Hammond and Associates Proprietary Limited and the State of New South Wales and others.
These matters were heard in Canberra by the entire court. Justices McHugh, Gummow, Kirby and I would answer the questions asked in the first case as follows. 1, yes. 2, yes. 3, the defendants.
Section 90 of the Constitution says that the states are not permitted to levy excise duties. So the High Court has had to decide what is an excise duty, because if the definition of excise is narrow, the states have broader access to revenue. If the question of what an excise is regarded broadly by the High Court, then it has serious repercussions for state revenue raising capacity.
The court will adjourn and reconstitute in court number 2.
The High Court, by narrow majority, decided that, generally speaking, sales tax would be regarded as a duty of excise. The effect of the decisions has been to dramatically reduce the revenue raising capacities of the states.
What this judgment does is it confirms the trend, particularly since 1949, that the states are really kept out of the area of raising revenue from indirect taxes on goods.
They can't read the minds of High Court judges, as is quite clear from other recent cases, and I think that there'll be a long negotiating process.
We've had these statutes declared unconstitutional. New South Wales raised $850 million from these taxes, which have today been declared invalid. That revenue is lost until it can be regained by the Commonwealth.
So the states have to really stop collecting that from today?
Yes.
More and more financial controls are going back to Canberra, and to us that is totally unacceptable.
It's almost as if the High Court is trying to make Australia ungovernable.
This whole absolute debacle.
This is a constitutional crisis.
That's an area where I think we really do need amendment of the Constitution, looking at the whole problem of revenue raising and distribution of money between the Commonwealth and the states, but looking at a particular couple of focal areas where I think it's the existing Constitution and the High Court's interpretation of it that has added to the problem.
I, Ian David Francis Callanan, do swear that I will bear true allegiance to Her Majesty Queen Elizabeth II, her heirs and successors according to law, that I will well and truly serve her in the office of Justice of the High Court of Australia.
Mr. Attorney.
The freedom of others to examine and comment on the work of courts is essential in our form of democracy. Your Honour should not be, and I'm sure will not be, unduly sensitive to critical reviews of your judicial work. I have no doubt that Your Honour will consider every matter that comes before you on its merits, based on the facts and arguments that are presented to you. You'll deal with these matters in a fair and impartial manner. Public confidence in the judiciary goes hand...
A new judge may change the balance of the court, and thus alter the resulting interpretation of the Constitution. But it is only the people of Australia who can alter the Constitution itself.
Australia is necessarily its own legal entity, with no power being left in the Imperial Parliament to affect the future of this country. The future of this country must therefore be charted under our Constitution. That Constitution is in the hands of the people so far as Section 128 places it there. Therefore, the people of Australia have ultimate sovereignty in this country. They can change the Constitution as they, but only they, see fit. Now, what does it mean in practical terms? It means, I think, that the whole of our legal system must be infused with the understanding that we are a democracy. And if we are a democracy, it means that there must be some basic egalitarian values which underlie our legal system.
Vote yes for Aborigines, they want to be Australians too. Vote yes and give them rights and freedoms just like me and you. Vote yes.
The Constitution was changed by overwhelming vote in a referendum in 1967 to allow the Commonwealth Government to make laws for Aboriginal people. But does this mean only for the benefit of Aboriginal people, or can it also mean to their detriment? In Cabinet papers now released, it is clear that the Holt Liberal Country Party government intended that the change would be for the benefit of Indigenous Australians.
Vote yes for Aborigines, they want to be Australians too. Vote yes and give
The referendum in 1967 was intended by the people who voted to give the Commonwealth Government the power to make laws for the advancement, benefit of Aboriginal people.
In argument before the High Court in the Hindmarsh Island Bridge case, the court is being asked to find exactly what the constitutional change of 1967 means. But before that case can begin, another matter must be decided.
The High Court's newest judge, Justice Ian Callanan, is to decide overnight whether to stand aside from the vital Hindmarsh Bridge case. Aboriginal people have asked Justice Callanan to exclude himself because he's previously given legal advice on the issue. Their lawyers said there's a perception the judge might not be impartial.
As a Queensland barrister, he gave advice on the Hindmarsh Island Bridge Bill that the Commonwealth has plenary power to introduce racially discriminatory legislation.
You have to let that one chat first.
Justice Callanan hears arguments from both sides on whether he should disqualify himself from hearing the case. He finds that there could be no perceived bias, in part because his recollection is that his advice was not provided directly to the Minister for Aboriginal Affairs. He decides to sit.
The High Court of Australia is now in session. Please be seated.
Call the matter for hearing.
For hearing, Carlton Yerry and another, and the Commonwealth of Australia.
In our written submissions, we say that in substance what happened in 1967 was a repeal and reenactment of this provision. Not merely the deletion of the words. And that, as so understood, it reflected a founding intention which was relevant in 1967. Just as one looks at constitutional convention debates to see that in the 1890s people had in mind discriminatory laws, so one looks at the position of the community in 1967 to see that no one contemplated such laws.
Are you not necessarily saying that there comes a point at which this court must say the Parliament, acting at least reasonably within the confines of legislative power, could not properly have deemed it to be necessary to make this law for this race?
Yes, as a special law. I mean, I include the whole phrase.
What we say is that the Constitution, when originally adopted, always intended that the race power should be applied in accordance with general community standards. Originally, discriminatory acts were justified because community standards of that era approved of such legislation. However, by now, the Australian people won't tolerate racially discriminatory legislation. And if we're right that the Constitution was always intended to adapt to those changing circumstances, then we're not changing the meaning of the original words, we're just saying that they apply in a different way.
Is it your submission that it is impossible now or any time in the future for the Commonwealth to pass a law under the race power which is to the detriment of a race?
Yes. Unless the external objective facts to which I've referred most recently as uncontested values change.
Suppose Aboriginal landholders in a certain part of North Queensland came across great mineral wealth, and you wanted to put a special tax on it. Now, you couldn't use the taxation power because it might discriminate between parts of states. Why couldn't you use the race power to impose the tax?
If you can't use the taxation power to impose a tax, you shouldn't be able to use the race power. There's no reason for the race power to extend to the law with respect to taxation. And there's every reason for saying that principle, that it was discriminatory against the state, should apply in this case, and the Commonwealth shouldn't be able to get around it because it happens to be owned by Aborigines, but the one on the other side of the boundary happens to be owned by a white man, and it's exempt from taxation.
Usually the court says whether or not there should be legislation on a particular subject is a matter for Parliament and not the courts. So here the question will be one of, we believe this is, the Parliament says, we believe it is necessary to pass this special law for the Aborigines, namely the Hindmarsh Island Bridge Act. And the question is whether or not this particular power is of a character that has some bounds, namely that just because the Parliament says it's necessary doesn't mean that in all cases the court has to accept that that's so.
Given the history of the developments of this century, not only in our country but in our country, and the referendum, that we reached a point where the power was changed, and it was changed with the authority of the people, to make it a power, if not for the benefit, principally of Aboriginal or Torres Strait Islanders, but of people of race, then at least not to prejudice them. That is part of history. That is part of the history we can't ignore, and that it was a power transmogrified with the authority of the people by the 1967 referendum.
Well, Your Honour, I was going to come to the referendum, but I think Your Honour's question postulates that there couldn't have been a change in constitutional meaning without the referendum. And we would submit that that must be so, that the constitutional meaning must remain constant. In our submission, Your Honour, the suggestion that the people of Australia...
But you just ignore completely the change of the world, the change of society, the change of attitudes. You're stamped with the meaning of prejudice of 1901. I could never accept that.
Your Honour, it's the words of the Constitution which control the meaning.
The words take on their colour with changing circumstances, changing attitudes.
Your Honour, this is not a change of colour, it's a change of absolute meaning.
The Commonwealth's argument was, whatever the view of each member of the court as to whether or not this particular law was a beneficial law or was a law which was prejudicial to the persons of an Aboriginal race or a group of the Aboriginal race, it remained a matter for the Parliament and not the court to determine that matter. In other words, it was put that it's a matter not for the judicial sphere but the legislative sphere. And if that argument is accepted, then the matter will be determined without the judges having to express any view as to whether or not they regard such a law as a beneficial law or non-beneficial law.
Your Honour, with respect to...
But I was just going to also put to you, Dr. Griffith, that another view is that the term special law itself is a limitation which is justiciable, and to be special it must discriminate in some fashion, whether detrimentally or advantageously, doesn't matter, but if it does, it has to have some rational basis, and it's the court then to say that there is no rational basis for this law.
Well, with respect, Your Honour, it may narrow subject matter, but not narrow power.
How would you apply that distinction to the case of Nuremberg-type laws, which after all were race laws, or to land area laws such as were enacted in South Africa? Now, would they be permissible under this power?
Your Honour, they may well be. The racist power is inherently a discriminatory law.
In a real sense, constitutional law is applied philosophy. You talk about ideas. I don't think I can think of one case where I have pleaded confident that I must win. One is dealing with an area of uncertainty in constitutional issues, and that really is how it is in the High Court. One can never be sure, and you always, in the oral argument, expose new areas which you try and foresee in your preparation, but which very much you have to be ready to deal with as they arise, and to deal with them, one hopes, decisively and in a satisfactory way, which does not have the effect of losing what might be the crucial view of one or two or more of the judges.
Your Honours, can I just get clear in my mind, is the Commonwealth's submission that it is entirely and exclusively for the Parliament to determine the matter upon which special laws deemed necessary, whatever the words say, or is there a point at which there is a justiciable question for the court?
Well, Your Honour...
I mean, it seems unthinkable that a law such as the Nazi race laws could be enacted under the race power and that this court could do nothing about it.
Your Honour, if there was a reason why the court could do something about it, a Nazi law, it would in our submission, Your Honour, be for a reason external to the races power. It is very difficult pleading to a court which does not intervene and ask you questions and give you an idea of what matters concern the court. Sometimes the interventions are made by a judge who is having great difficulty or disagrees entirely with your approach, and you deal with that as best you may, on some occasions getting to a point of a truce where each party makes it quite clear as to how it puts the case but understands that the other does not agree with it. And you must accept when you plead a case that where there's 7 judges, what you aim for is to get at least 4, and it may well be on occasions that you'll lose 1 or 2 on the way.
The cumulative wisdom and knowledge on the Constitution is amongst the 7 is so much greater than any individual advocate can have that one never knows where one is going to be attacked from next. Rise, please, our submission.
Thank you, Mr. Spiegelman. The court will consider its decision in this matter and will adjourn until Tuesday next at 10:15.
Cartonieri and the Commonwealth ended after 2 days of hearings in Canberra. On the 31st of March, the Howard government announced that the Chief Justice of New South Wales, Murray Gleeson, would be appointed the new Chief Justice of Australia.
Good night, Daniel. Good night, Michelle. Am I reluctant to go? Yes and no. I will certainly miss both the camaraderie of the court and the daily challenge of the work that it presents. On the other hand, I shall look forward to seeing my wife, my children, my grandchildren, and a lot of other interesting things that I haven't had time to see or to do. I've been privileged to be involved in some extremely interesting exercises which have affected Australia and the community to which I belong and to which I am, if I might say so, passionately devoted. If there was a better understanding in the community of the role and the importance of the role of the judiciary, much of the difficulty, much of the misunderstanding would be eliminated. It is oftentimes thought that the courts are, as it were, an agency of government. They're nothing of the sort. They must stand independently of government. And if they get too close, then the freedom of the community is at risk.